Hello, ladies and gentlemen. Thank you for being here today with us. This panel will explore GenAI and law, regulation challenges, and the future of legal practice. AI has been taking the world by storm. It's everywhere, and every single day we hear about a new app or a new feature. In the world of generative AI, creativity knows no bounds, and businesses have endless possibilities. My name is Christina Grigoriadou. I'm an economist and an attorney at law. I'm a senior associate at Moussas Partners Law Firm in Athens. The firm acts for clients from a variety of industries and countries before local courts, as well as before international arbitration fora. I will now present you the three esteemed panelists. I will start with Professor Vlachopoulos, Professor Spyridon Vlachopoulos. He's a member of the University Senate at the University of Athens. He will elaborate on legal responsibility arising from AI application. The next panelist, Mr. Kostas Argyropoulos. He's a general counsel at Space Hellas, Chief Legal and Compliance Officer. He will speak about making smart choices in selecting AI tools for the right purpose. And then we have Konstantinos Anagnostopoulos. He's an attorney at law at European Legal Tech Association Ambassador for Greece. He's a director and co-founder at Athens Legal Tech. Mr. Anagnostopoulos will talk about generative AI and the legal profession. Thank you all for being here today. Thank you for your time. So, Professor Vlachopoulos, should we start?
Yes, of course.
All right.
First of all, I would like to thank you very much. And I would also like to thank the organizers for the invitation, and especially Mr. Stamatonicolos for the invitation.
Yes.
It's a great pleasure to be among you.
Should the legal responsibility arising from AI applications be regulated or not? And if yes, to what extent?
Yes, the answer to this question is absolutely yes. So the question should be to what extent, because I think that no one doubts in this room that it should be regulated for many reasons. First of all, for legal certainty, and second, I have to say that compensation for damages caused by human actions or by technological developments is an essential part of the rule of law. And this is the case law of the Council of State, of the Greek Council of State, and also of the European courts. So there is no doubt that it should be regulated. The question, as you have already said, is to what extent? I think the regulation of artificial intelligence applications should not go into detail. It should put only the frame, because if it goes into detail, then I think that it will be very soon outdated. So only the frame, only the general principles, so to say, and we shouldn't put too many obstacles to the technological developments. And there is also another thing we have to consider, the fact that if we put too serious obstacles to the technological development in Europe, then I think the companies coming from Asia or from other continents will have the advantages comparing to the European companies. And this is something we do not actually want, because we already know that the advantage is in the other continents. So we should be very careful putting the general principles and not detailed provisions, so to say.
Thank you very much. My next question is, which is the appropriate tool for regulation? Bill, administrative act, code of conduct, something else?
Okay, that's a very good question. First of all, I think that the provisions should come from the European Union. There is no meaning introducing national provisions. So we should have provisions at the European level, at the level of the European Union. Of course, it would be better if we could have provisions arising from the international law, covering all continents and all countries. But I think this is something very, very difficult. So we will be very happy if we will have some provisions, directives or regulations or acts. We're all waiting for the Artificial Intelligence Act. I'm not quite optimistic about that, but we will see what happens in the next year or years. So I think all provisions should come from, at least from the level from the European Union. Yeah. So I think for the national legal order there is no special room in order to regulate the artificial intelligence. Of course, some administrative acts or some ministerial decisions could come into force. I think, but I believe in the meaning and in the importance of the codes of conduct. For many reasons, I have to say. First of all, I think codes of conduct, the professionals are more willing to comply with the rules which arise from the codes of conduct because they are rules which come from their profession, first of all. Second, I have to say that the codes of conduct have a preventive nature. And it's very, very important to stress that artificial intelligence and generative artificial intelligence does not mean that you can use every product of artificial intelligence. So the codes of conduct say to the professionals, watch and look, you should be very careful. You should also comply with some rules which are proper for your profession. And another thing is that I think that the rules which have to do with the liability in the frame of artificial intelligence are not the same in every profession. So codes of conduct coming from each profession and which are fit and proper for each profession are just rules. So we should not have detailed, so to say, provisions, law provisions covering all professions in the frame of professional liability, but codes of conduct which are fit and proper for each profession. I think codes of conduct, perhaps, of course, we all know that it belongs to the so-called soft law, but I think perhaps it's the proper tool for regulating artificial intelligence.
Yeah, that would ensure a framework for every profession, and it sounds
yes.
Reasonable. So, should we introduce the objective responsibility or the reverse burden of proof?
Oh, that's another good question, I think. Well, about objective liability, I'm not quite sure. Because I think that if we introduce objective liability, then I think we put too many obstacles for technological development. I am more in favor of introducing the so-called reverse burden of proof. That means that the producer, the manufacturer, has to prove that the damage caused to other persons does not arise from the artificial intelligence application. So I think this is something which I could describe as fair balance between, on the one hand, improving and allowing technological development, and on the other hand, ensuring the rights of the people, of the persons who are perhaps damaged by the applications of artificial intelligence. And I think we should also be very, as I have already said, I think that we should also introduce codes of conduct, and we should not forget that the liability can be also on the side of the user of technology, of artificial intelligence. That means that, for example, if I'm a lawyer, attorney of law, and ChatGPT produces a legal text for me, that does not mean that I'm going to file the application before the court. I have to read the product which arises from the ChatGPT. So we should also speak about the liability not only coming from the manufacturer producer, but also for the liability of the users.
Yes.
And perhaps also for the third parties, and also for the liability of the persons who are damaged by the applications of artificial intelligence. Look, for example, the autonomous cars. We have the autonomous cars without drivers. This does not mean that the pedestrians or the drivers of the other cars do not have to follow the traffic rules. So liability is something which does not have to do only with the manufacturers and the producers of artificial intelligence applications. It has also to do with the users, and this is something we should stress, with the users of the artificial intelligence, and also with the other people who are also damaged, perhaps damaged by these applications.
Yeah, very good point. And we recently saw what happened with a lawyer in the US who used ChatGPT for a case, in personal injury case, and he used case law that didn't exist. Okay. So he was fined because of that.
Which you should also see what happens with the students who use artificial intelligence.
Well, someone has to take the first step, right?
So that's a big question. Another big question, artificial intelligence in the frame of education and in the frame of the university. This is also a very good question.
Yeah.
Perhaps the subject of another conference.
For another one, okay. My last question is, should we adapt the categorization of AI implications, high, normal, and low danger?
I would say yes. There is a big difference between dangers of high risk, of low risk, and normal risk. So if someone produces artificial intelligence applications of high risk, then I think he should also take into account that no mistakes are should be allowed. And this is something actually which is not new. And if you see, for example, in the data protection legislation, then we have also differences between high-risk situations and low-risk situations. We have also the difference between sensitive data on the one hand and the so-called simple data on the other hand. If you look at the environmental law, you have also classifications, categorizations between high-risk situation and low-risk situation. And the environmental assessment is also something which differs from situation to situation. So I would say that yes, the differentiation, categorization between high risks and low risk and normal risks, which is also the essence of the draft of the directive for the liability in the frame of artificial intelligence, is something that can be, under circumstances, very useful. This is my point of view.
Thank you very much.
You're welcome.
Thank you. So now we will move on to Mr. Argyropoulos. Thank you, Mr. Argyropoulos. So should I start with the first question?
Yes.
Which are the challenges faced by the adoption of AI in cybersecurity?
Thank you so much for this invitation. It is so nice once again to be part of this group of distinguished colleagues, and honestly an honor to be invited with the presence of our Professor Vlachopoulos. It's really an honor. Look, Greece is among the top 10 countries in the world that are most exposed to cybercrime. This is according to a report that has been recently published to the press. And meanwhile, according to the Munich Security Index of 2024, cyber attacks now run as the top concern in China and US, and the second worldwide after extreme weather. So, speaking about AI, in response to this growing threat, many companies are turning to AI as a tool for their cybersecurity needs. And AI-based systems have the potential to revolutionize how we protect data and systems from bad actors. They can also assist with use cases in cyber insurance and cyber due diligence. However, any tool and its effective outcome could not work without people. And this is an EU problem, as the EU needs a bigger pool of cybersecurity specialists to protect businesses and public services in Europe and design the cybersecurity solution of the future. Currently, around 200,000 cybersecurity experts are missing in Europe. Recent legislative initiatives like the NIS2 and the upcoming Cyber Resilience Act will put even more pressure on companies and public authorities to have access to cybersecurity experts. And to address these challenges, the EU is moving towards the Cybersecurity Skills Academy, which would constitute a European umbrella integrating various activities with the objective of increasing their visibility. And it will also improve coordination in view of boosting the EU competitiveness, growth, and resilience. It is important to have in our minds that cybersecurity is not technology, it is security. Especially with the use of AI tools, we should concentrate on this goal, meaning to close this cybersecurity gap with cybersecurity experts in all levels in markets and education. There will be also new fields born, including legal. There clearly would be people in the near future who will say, hey, I am an AI ethics lawyer, I am an AI human rights lawyer. And all this we will see in the near future that, especially in our legal field, will get in contact with such very interesting new specializations. And finally, speaking about education, I want to say that in our company, in our group, we are very proud that we have a scholarship program in the memory of our founder, Dimitris Manolopoulos. We provide each year 2 scholarships to young students who want to continue with their studies in Greek universities in a postgraduate level in the fields of ICT, AI, and cybersecurity.
Thank you.
Thank you.
Thank you very much. Yes, cybersecurity is a huge issue, and I think we could discuss for a long time. Which is the role of AI in the business, and how is the AI integrating into the corporate governance systems?
Well, this is another very interesting issue. I mean, what is related with AI and the business and corporate governance. We know that as with any emerging technology, AI presents opportunities for competitive advantage and innovation, while also presenting significant potential for risks. And governance systems in business need to assess the impact of AI on corporate strategy and risk, and specifically consider how AI is used. For example, to support innovation and R&D, to manage the supply chain, to reduce risks or otherwise improve efficiency or reduce costs. AI for sure will raise compliance issues that requires a consideration in a decision and board level business-wise, and a redefinition of the company's governance structure. To be compliant with AI standards, we do need new policies that will be AI-focused, but at the same time balanced, meaning that AI's intelligence and its final goal are not necessarily correlated. We know that we can have unintelligent machines that serve us well, and at the same time we can have super intelligent machines that harm us. So intelligence alone does not guarantee against harmful behavior. So AI systems, yes, can incorporate bias and lack transparency, which may lead to concerns about equality and accountability. Additionally, AI systems are heavily reliant on data and often implicate privacy and data protection regulation. Also, the use of AI may have implications for intellectual property protections. It is AI now the focus of, as Professor said, of legislative and regulatory initiatives, both in European Union and overseas. It is important to say that the Court of Justice of the European Union just published an interesting AI strategy report, very AI-friendly. And one of the proposals is to create a specific AI management board to integrate it alongside the other existing boards in an effort to create the mechanism which will ensure governable AI. So it is important boards to understand and stay apprised of these developments and oversee the organization's compliance, as well as the development of relevant policies, information systems, and internal controls to ensure the use of AI to be consistent with the framework's obligations and with appropriate safeguards to protect against potential risks. So in doing so, the boards should be mindful of the variety of ways in which the company may face exposure to AI-related compliance and other risks, including through AI technology that is internally developed or licensed from others, or even acquired through a mergers and acquisitions activity.
Yes, very, very important, and it looks like we're going to see development soon on that. From corporate governance.
It is a specific domain. I mean, we have to look at what happens inside the corporate environment with the use of AI, which will be in the next months or even next few months something very practicable.
Yeah, it looks like as we saw the ESG standards, now we're going to have the AI.
Yes.
Probably.
Also, there is something very interesting about the public procurement, the public contract. What will happen if, let's say, a company uses an algorithm in order to attend the execution of the contract, and this machine gives a wrong delivery date, and the company will have to face sanctions of the awarding authority. It's
not easy.
Many different, aspects of this same problem, which is the use of the AI, and which are the conditions in order to take the right decision to select the right tool.
Yeah, maybe.
Because we have many tools. We have open source tools, we have Chinese tools, we have the French tool, we have the US, of course, tools.
Yeah, unlimited options. How important is the social cost of getting a call wrong?
So this is a very interesting thing, I mean, also legally wise. It has to do with the oversight of AI, how AI oversight affects human decision-making. This is an important question. Thinking that in our environment, algorithms will play an ever larger role in everyday life. We know that AI systems assist humans to reduce the number of mistakes that they make while performing tasks, and there are cases that the final decision is on the human side and cases that AI is given the final decision instead. AI has also begun to overrule decisions as a part of a quality control measure in a variety of industries like the financial trading or the energy management, or in the air traffic control also, or in the car industries, as Professor said. However, very little is known about how humans respond when their decisions might be overturned by AI, because being overruled can carry psychological costs, for example, shame and embarrassment of being overruled, and at the same time psychological advantages, benefits, for example, the relief of at having their mistakes fixed. Individuals might alter their decision-making under AI oversight. So with AI oversight, humans are in charge of making decisions, but these decisions are placed under AI scrutiny and potentially overruled. It is an open question as to whether humans respond differently to human and AI monitoring. AI technology for sure extends and will extend the rate of scenarios where monitoring becomes operationally or economically feasible, as there are settings where AI monitoring is less costly, quicker, or more effective than human monitoring. And coming to a conclusion, the most important is the social cost of getting an important call wrong, which is the question, which will vary between disciplines and could distort decision-making in different ways. For example, judges may prefer to under-convict, or doctors, on the other hand, might overdiagnose.
Yes, very problematic, I think.
It is. We are going a little bit behind.
Yes.
I mean, all these systems. But at the end, we will see in the future that AI monitoring systems will play a crucial role on oversight of humans.
Yes. Yes. Thank you very much.
Thank you.
Thank you very much, Mr. Argyropoulos. Now we move forward to Mr. Anagnostopoulos. Thank you for being here.
Thank you. Thank you for inviting me, and I'm humbled to be with Professor Mr. Argyropoulos of Space Alas here, and with you, Ms. Grigoriadou, and to discuss about these real-time happenings, actually. It's not the future anymore.
Yeah. My first question is, what is the current market status and sentiment on generative AI in the European legal market?
Well, the sentiment is surprisingly positive across Europe and across market segments, and the market is vividly experimenting. With European Legal Tech Association, we did a survey late 2023 in collaboration with Laffer Sarut and ECLA. ECLA is a European Companies Lawyer Association. They house legal departments. And we surveyed approximately 300 professionals, demonstrably experienced professionals, 10 to 15 years plus, with a self-evaluated, at least high level of digital and IT skills. And the findings are illustrative of the high spirit in the market. 87% they use generative AI. We're talking about professionals across all the legal market segments, meaning law firms, in-house legal departments, alternative legal service providers, and academic and public sector. 87% of them are using generative AI. 44% of them, they're using it on a weekly basis. 24% on a daily basis. They claim to use it for non-legal text production, but I don't believe them. I think they do legal text production. They claim they do it out of curiosity, which I don't really believe. So I think it's a 29% plus a 28%, which they tinker. It's people who tinker with legal text, but I think, in my opinion, they don't want to say it, they don't want to admit it. And then we have a rest of the percent that use it for summarizing purposes. Most preferable LLM model is ChatGPT, 73%, followed by 13% of derivative and very specialized models. And we have a surprising of 77% who believes that it will augment their possibilities and abilities and will significantly help their job. Followed by a very, very low 13% of fearing job replacement. I don't know whether it's so positive and optimistic, but these are the findings. And their experience averages with ChatGPT from 6.3 out of 10 to 6.9 and 7.7 for derivative and specialized models, which is really important. 62% believes that GenAI has an impact now in the industry, and 24% in the next years. Most of them believe that it will affect secondary legal work, meaning drafting documents, summarizing legal search, and anything that is related to secondary legal work. And top priority for their concerns is privacy and data security, which is important, algorithmic bias, and accountability and liability.
Eye-opening data.
It is eye-opening. Essentially, they illustrate that the people Because, the difference between GenAI and the legacy AI is that GenAI, it is conversational and thus very user-friendly, which means that you don't expect a supercomputer in a laboratory in Democritus to do the job. It's in your laptop. Yeah. So that changes completely the game, and that changes the experience. And it's really important to see that the more frequent the usage, the more optimistic and confident the user. Yep. So if you do an analysis of our findings, you see that people who use it on a daily basis, they actually feel more confidence because they have seen, they have touched Jesus, Yeah,
they have experimented.
Yeah, exactly.
Very interesting data, and I've seen your survey, and it's really interesting to see. Very good work.
Thank you.
So, next question is, which are the main challenges that accompany the integration of GenAI tools into legal practice?
Well, if there is something we have that is challenges, I have to say, I would start with the bedrock of our society and of business, and it's called trust. And trust origins from a very specific case functionality, meaning, does this technology work? Because if it works, then you have trust, then you have the client acceptance, then you have the justice ecosystem integration. And then you mitigate the risk of over-relying on AI decisions. So key, the alpha and the omega, is whether this technology actually works. And then we have the major legal concerns, as pointed out by the professor and Mr. Argyropoulos, like the algorithmic bias, fairness, serious issues of privacy and data security, especially if you are a European lawyer and you're dealing with Europe, the ethical standards, interpretability, and accountability. And then we have the practical challenges of a legal department and a law firm or a law school. We have liability insurance. Let's say that a lot of people here, they're tinkering with LLMs. Have you checked whether your professional liability covers the use of AI tools? That's number one. Number two, really important, cost constraints and resources allocation, especially for continental Europe. We don't really have the Silver Circle and the US, budgets of grossing $2-3 billion per year. So can you afford the tools? Can you afford the training, the education of lawyers? Can you afford all these? And plus, can you afford the integration into the existing systems? Because you can have a Microsoft license for this, and then a Huawei for that, and then a Chinese for this, and then Mistral for that. Okay, so now Mistral is partnering with OpenAI, and then you have the Perplexity model, but Perplexity is better because it's more accurate, and then this, and then that, and then you have a proprietary that Dentons is using, blah, blah, blah. So all these practical barriers that I don't really see how they will be overcome right now. And then there is a fourth one, but I will leave it as a final. There is a fourth category, but I will leave it as a final remark because I think that's the most important after trust.
Okay, all right. We'll
I'll keep you. Yeah.
Okay, thank you. So my last question for you is, what is the future of GenAI in the legal sector?
I'm sorry?
What is the future of GenAI in the legal sector?
Well, I think it is great for secondary legal work. It is tremendously great. I don't see anywhere in the near future a huge paradigm shift. And I'll tell you why. Secondary legal work is what we describe document drafting. It's probably some manual work like tagging documents, summarizing documents, etc., etc. Anything that is very logistical in lawyers' world. I think we have two issues when it comes to succeeding in the secondary legal work, and one is trust, And that corresponds also with what Mr. Argyropoulos said before about the mistake. You know, I make the prediction that in the next 2-3 years, they're already doing it. The big European law firms and Anglo-Saxonic ones, they sandboxing this technology into their systems right now. You know, there are a lot of specialized tools like Harvey, et cetera, which are proprietary, and they're being under, you know, training at the moment in the big law firms. So they're already sandboxing it. I predict that for the next 2-3 years, they will use these technologies, but they will not publicly admit it. For 2 reasons. One is the trust that comes out of functionality, whether 100% delivers the promise, because if it's not, then you will not publicly admit it, and because trust and whether it works is, you know, it's not, you know, it's a thin red line. It's not, you know, sometimes you have to take the first step and go to the moon. So I think a lot of firms, a lot of legal departments will be reluctant in admitting to use GenAI tools, because one grave mistake and then it's finito la musica, passata la festa. It's done. So I think for 2-3 years, we're going to see a huge growth for secondary legal work, but they're not going to admit it. And that's because of trust. And the second, which I think is the most important, and even if we gain trust, and even if we gain the technical ability to perform 100%, and we have a civil lawsuit of 250 pages for a very specialized case being written in 1 second, we have a huge problem, and you have a huge problem, and you have a huge problem, and I have a huge problem. It's called business model. The market and the society is not ready yet, Mrs. Grigoriadou, for you to go to a client and tell the client, you know what, I ChatGPT the arbitration clause, and ChatGPT was correct. And the client will be, oh really? You ChatGPT it? How much time did it take you? 5 seconds. Oh really? Then I'll pay you 5 seconds. I'm not going to pay you 20 hours billed. So I don't see anywhere in the market in the next 2-3 years the recalibration of the business model. Nowhere near that. And I'm not sure if down the line, 5-10 years, we will be ready as a market and a society. Because, you know, you have to make money out of the inefficiencies. Because if it's a super efficient market, then you're not needed. So I think it's a major problem. And I think that we will face this problem, because I think 10 years down the line, you know, legal, I think, will be disrupted in a major fashion. And the reason is because we have a very codified and standardized text and reasoning, and very, very few originalities. I think we will face this dilemma. And then it's about the market and the society to try to adapt and come up with new outlets of revenue.
Well, I think society doesn't have another option than adapting, probably.
Well, no, it's not that easy, because there are civil procedures right now that could be automated with your finger on your laptop and with gov.gr in the court system. There are tens of very simplified civil law procedures, but they're not being disrupted. Why? Because society is not ready. And then you see the minister giving this, you know, this option, then, you know, delivering this to the legal, to the bar associations and not to the courts, because it's a matter of revenue and business model and market structure. So I think that's the future.
Yeah. Thank you all for the very enlightening discussion and the insights, of course. Definitely many good things can come out of this. For example, education, it was mentioned also earlier, could benefit a lot, and many people could be empowered to share their ideas more easily, even with fewer resources. My thought, as I shared with Professor Vlachopoulos, is not the question whether AI will be regulated, but how, because that looks like a very challenging area the way that's going to be done. So if we capture 3 different jurisdictions and see the developments, US, EU, and UK, to better digest the rapid development of AI regulation across the globe, we will see that there are differences in the way they approach. So both the EU and UK have stepped up to the AI regulation plate with enthusiasm, but have taken different approaches. The EU has put forth a broad and prescriptive proposal in the AI Act, which aims to regulate the AI by adopting a risk-based approach that increases the compliance obligations depending on the specific use case. The EU AI Act is the world's most and first comprehensive AI law and introduces obligations for providers, product manufacturers, importers, distributors, and deployers of AI systems, and for providers of foundation models. Its final adoption is expected soon, and then it will become directly applicable in Greece once the transitional implementation period expires. The UK government has adopted a cross-sector and outcome-based framework for regulating AI underpinned by 5 core principles. On 6 February 2024, UK government unveiled its response to last year's white paper consultation on regulating AI. This approach contrasts with other jurisdictions such as the EU and to some extent the US, which are adopting a more prescriptive legislative measures. US has pushed for national AI standards through the executive branch, but has also adopted some AI-specific rules at the state level, both through comprehensive privacy legislation and for specific AI-related use cases. So between the 3 jurisdictions, there are multiple approaches to AI regulation that can help strike the balance between developing AI technology and ensuring that there is a framework in place to account for potential harms to consumers and others. Given the explosive popularity and development of AI in recent months, there is likely to be a strong push by companies, entrepreneurs, and tech leaders in the near future for additional clarity on AI. So handling this AI wave and its impact should be the most urgent priority of governments in the incoming years. That's my personal opinion, of course. Regulating it, yes, but also anticipating how difficult it's going to be. Our society will be definitely different from now on. We'll adapt, but I welcome the speakers' thoughts on all that for the future, and any other thoughts they'd like to share with the audience?
Professor,
you can have.
We start with the law studies first.
Okay.
No?
Okay.
No, because that's a question for you also. I mean, let's say that in 10 years it is technically feasible to have 100% accuracy on these text and legal. What is the future of law studies? What does it look like? I mean,
that's a very difficult question. Of course, I think. In the law studies, the most important thing is to think. It's not just reading the legal text. It's not giving the answer. It's just think and trying to find arguments pro and contra. It depends on which side you are. So I think if we use too much artificial intelligence in the law studies, I think it will be the end of the traditional way of law thinking as we have experienced that in the continental Europe, also in Great Britain. I think in the United States of America. So I think the use of artificial intelligence applications in the law studies will not be the same as in mathematics, physics, and other sciences, other scientific branches. It's another way of thinking. Yeah? And also, I have to say that the lawyer must have the general education, so to say. For me, the good lawyer is the one who has the good general encyclopedical education. So for me, the good lawyer is not what they call in Germany, for example, Fachidiot, there's someone who knows very well a specific subject, someone who has learned to think, has learned to think critically, and someone who combines different pieces from many branches. So I'm not quite sure that this can be substituted by artificial intelligence.
Yeah,
this is my point of view.
Yeah, I totally agree. It looks like not, but we'll see.
We'll see.
We'll see. We'll be here to see what happens. Any other points from panel?
Well, I think that AI, GenAI is for sure a reality, and we will see it from now on. In the information technology, they say that if internet is like a car, AI is like putting a rocket behind the car. And I'm seeing right now there is a very interesting tool in the OECD site which registers the different incidents daily for the member states of the OECD. I'm seeing right now that all these incidents are more and more day by day. Right now, in 50,000 articles, we have around 10,000 incidents. In my opinion, I'm more in favor of AI for all approach. We need the GenAI, and of course, we must go step by step in order to profit from this technology, which will be in our environment daily.
Thank you. Any other comments?
And the last thoughts before dying into eternity? I don't know. I think, okay, I'll share with you two things. I will say a buzzword that was pinned around the media 10 days ago with the interview of CEO of NVIDIA, and it's called sovereign AI. I think it goes to professors' scientific focus and interest to the constitutional law. So I think as NVIDIA CEO proposes is that each country should have a sovereign AI, meaning infrastructure for its own tools, for its own systems. I don't know if we can afford that in Greece, but certainly we can afford that in the EU region. So I think the buzzword of this year will be sovereign AI, if not decades. And the second, which is really important if we want to see this change we discussed about, is open data. Without open data, we're going to stick to the secondary legal work. And maybe we want to, but, I think these two, sovereign AI and open data, I think, it's probably, different, it's the same coin, but different aspect, but, two buzzwords, sovereign AI and open data this year.
And just to say something very important, that this year is a year of elections in worldwide, in many United States or
and the year of the dragon
and the European Union, and we will see how these AI tools will work. Our group is responsible, let's say, in Greece, because we have the software to organize the counting of the European elections in Greece. And I watched this with very much attention, because we see that the most big, let's say, operators, they are closely to the AI tools in order to find a way to protect the use of the AI tools during the election. So this is something also that we'll see it in up to June.
Really important.
And maybe our professor can say something, because he's it's close to constitutional issues.
I think it's very interesting, because this has to do also with a relation between artificial intelligence and democracy.
Yeah.
This is a crucial question nowadays. And not only in the frame of elections, but also in the frame of the question if artificial intelligence application can substitute the decisions of organs, state organs, which are occupied by by humans, by the elected persons, so to say. So, from the point of view of constitutional law, artificial intelligence is something which is quite questionable, I have to say. So, very, very interesting. Yes.
Yeah.
Thank you.
Thank you all very much.
Thank you.
Thank you for being here with us today. I think we ran out of time, so because the timer has gone off. I don't know if there are any questions. Yes?
So, hello. I am a law student in the University of Athens, and I heard that you said that at the minimum, the secondary tasks in legal offices will be taken over by AI, at least in the beginning. But the secondary tasks are the tasks that the interns do at the law offices or the people who do their practices before they become lawyers. So this means that the demand for these practitioners will be much less. So how do you think this will affect the legal profession as a whole? Because if you don't train enough lawyers, because you don't have a demand for them, you will not have senior lawyers in the future. And yes, basically that's my question. And also, how does the legal AI come into academia, in the legal academia? Because we talk about GenAI here, and Mr. Vlachopoulos, I think, is an exception in the Greek university, because he knows about generative AI and talks about it, but the majority of our professors don't know the capabilities of AI, at least in the legal profession. So what are we doing about that? Thank you.
I don't know who wants to...
First, I just want to say that many professors have an idea of artificial intelligence, yeah? So I don't agree. I mean, I don't know in the law schools, but you have professors of artificial intelligence in other universities. So I think it's a branch which is expanding in the Greek academia, so to say. Concerning the question if we don't need many young lawyers who, because of the artificial intelligence and the secondary work they can do, I think someone has to read the text produced by artificial intelligence. If you don't, as I have already said, if you don't read the text, then I think it's quite probable that you are going to make a mistake, and then you are going to be obliged to pay compensation for damages caused to your clients. So I don't think that the artificial intelligence is going to lead, so to say, to an unemployment in our profession. That's my...
I have a positive thinking, I mean, of what you said about the use of AI either in the university or in the legal studies or in our practice as lawyers, because it is true that, as I said before, artificial intelligence will create new specialization, especially in legal studies. And this is something very interesting. I mean, to try to focus on cybersecurity. Let's say we will need cybersecurity lawyers, cybercrime lawyers. We will need AI lawyers. So think also the other side. It will create more different, let's say, areas and opportunities for lawyers.
Thank you.
You want me to answer too? I mean, look, you're not going to have a job replacement now because the market will not publicly admit they're using. That's number one. Number two, these tools are not only for practitioners because the European market is very fragmented into solo lawyers and small firms, etc., etc. So it's not like all firms are 100 people and 200 people and 1,000 people, and you have the interns, etc., etc. around. So I don't think we're going to have a job replacement scenario now, but we're going to have a fundamental scenario and paradigm shift in 10 years' time. I think we're gonna face that market structure, society thing, like, you know, okay, it works, and it works in a very high level, from the partner to the, to the pleb, from the pleb to the Caesar, and then, you're going to have, okay, so what we do now?
Thank you. Thank you all for being here today. I think we have to stop now. That's it.
Thank you.
Thank you. Thank you very much.